Welcome back to Court TV Live. I'm Chanley Painter. The Supreme Court is hearing arguments on Texas's controversial abortion law today. The first case, Whole Woman's Health versus Jackson, was filed by abortion providers, while the other was filed by the Department of Justice. Now, the law in question bans abortions once a heartbeat is detected, which is typically around 6 weeks, and includes no exceptions for pregnancies resulting from rape or incest. Now, the unique challenge of this law is how it's structured. Precedent under Roe v. Wade prohibits states from barring abortions before fetal viability, which is usually around 23 weeks. But under this new law, private individuals are instead deputized to sue anyone, really, who either performs the procedure or aids and abets it, making it difficult for challengers to know who to sue. So let's take a closer look at some of those key arguments made earlier today in the Whole Woman's Health versus Jackson case.
The combined effect is to transform the state courts from a forum for the protection of rights into a mechanism for nullifying them. As Respondent Dixon has said, no rational abortion provider would violate this law. While court clerks are not ordinarily proper defendants, in these circumstances, the principles underlying Ex parte Young authorize federal court relief against clerks. Their docketing of SB 8 suits, which is critical to effectuate Texas's illegal scheme, inflicts Article 3 injury in fact and is redressable by an order barring such docketing. SB 8 is an abortion prohibition, but the issues before this court are far more sweeping. To allow Texas's scheme to stand would provide a roadmap for other states to abrogate any decision of this court with which they disagree. At issue here is nothing less than the supremacy of federal law.
You say judges, at least in many circumstances, enforcer. There are 4 billion tort suits in the United States, okay? And probably in 3 billion of them, somebody thinks something's unconstitutional. All right, so can they all sue the judge? No. Everybody goes into federal court, sues the judge? And in the state court? All right, what's the difference between this case, where you think he's an enforcer, and 4 billion other cases where you've read their briefs? All right, you understand their argument. What's your response to it?
The response is that under the rule that we are advancing here is that where a state is trying to nullify the exercise of a right, a constitutional right that's been recognized by this court by delegating enforcement to the public and taking away the normal, ordinary executive officials, and then also creating special court rules in order to turn the court system. We're not saying that judges or clerks are intending to do anything here, but it's the rules that have been created by the Texas legislature that turn courts into a weapon that can be used to nullify constitutional law.
Your basic point, I take it here at this, as we've discussed it, is this kind of a private lawsuit is not an ordinary tort suit. Okay? So I've tried to write down the reasons, and I want you to add anything I leave out. 1, anybody can sue. Well, okay, debatable. 2, anywhere in Texas. Texas is a bigger problem than Rhode Island there. 3, it has no preclusive effect. Jones 1 sues the clinic, clinic wins, Jones 2 through 4,000 can sue. 4, the attorney's fees are very heavy. 5, and they don't apply both ways. 5, the penalty of $10,000, et cetera, is heavy. And 6, you are limited, if you are a defendant, as to which kinds of defense you can make in respect to there being an undue burden, which is a problem because most of the undue burden cases speak generally of the effect of the law of the state, not on this particular defendant. Okay? I have 6 that I caught from you. Is there a 7th?
I have 2 more, Your Honor.
Okay.
The first is that damages are not tied to the amount of any harm, which would be normally the case in a tort suit. And the second one is that SB 8 provides for a mandatory injunction if there is a successful claimant, to prevent further violations, not to prevent further harm to the claimant. It's not tied to, the mandatory injunction is not tied to the harm.
Here to discuss, constitutional lawyer Jeff Lewis and former District Attorney George Brockler. I'm going to start with you, Jeff. You were listening to the oral arguments all morning long in both cases. I'm going to get your general take on what stood out the most to you from the arguments today.
Well, keeping in mind that today we're not talking about does a woman have a fundamental right to an abortion. What we're talking about today are technical questions about whether or not courts or federal courts can hear these cases. What stood out to me is I heard questions from at least 4 conservative justices suggesting they're going to weigh in against Texas and allow the federal court system to overlook and review SB 8.
Now, George, do you believe that, agree with the Department of Justice here, the providers here, that if the court allows this law to go unfettered, that it could possibly affect all types of constitutional rights moving forward, not just a woman's right to an abortion?
I do. I mean, look, I'm a big 10th Amendment guy. I'm not a huge fan of when the feds step on top of the states. But this is such a unique set of circumstances and a law to try to address them that as the prosecutor, I worry about privatizing the ability to, in essence, prosecute. And that's what this is. And I agree with you, Chanley, that the concern there is if it passes the sniff test here, if this becomes codified in some constitutional law opinion from the Supreme Court, where does it stop? And I think if you're a fan of the Second Amendment, you got to think, the other side's going to pick up on this, and they're going to produce the exact same kind of law for issues like this. It is a Pandora's box that we have not yet seen opened yet.
And I think it's important, like Jeff said, to keep in mind, this is not a case going to the core constitutional issue of the right to an abortion. That's likely later, December 1st, in a Mississippi case. This is some procedural issues that, like George said, could affect more constitutional rights. And again, the court took up both the whole women's health issue as well as the Department of Justice suing the state of Texas on similar issues. We're trying to preserve federal sovereignty here. Let's take a listen to some of those arguments from earlier today.
You think the U.S. has authority to bring a suit like this against any state law that
violates this court's precedents and tries to shield that violation from any effective judicial review in federal or state court. And I recognize, Justice Kavanaugh, that this is an unusual suit. The United States does not lightly invoke an authority like this to sue a state. The reason we've done it here is because SB 8 is so unprecedented, extraordinary, and extraordinarily dangerous for our constitutional structure. If Texas is correct that it can nullify this court's precedents and it can successfully evade the mechanisms that this court recognized in Ex parte Young and Congress recognized in Section 1983, then no constitutional right is safe. And we think that in this extraordinary circumstance, the United States has a sovereign interest in intervening to protect the supremacy of federal law. Texas designed SB 8 to thwart the supremacy of federal law in open defiance of our constitutional structure. States are free to ask this court to reconsider its constitutional precedents, but they are not free to place themselves above this court, nullify the court's decisions in their borders, and block the judicial review necessary to vindicate federal rights. As this case comes to the court, there are 3 principal questions. First, is Texas responsible for this law? Second, can the United States sue to hold Texas to account? And third, is the injunctive relief available? And the answer is yes, down the line. Texas is responsible for the constitutional violation here. It enacted a law that clearly violates this court's precedents. It designed that law to thwart judicial review by offering bounties to the general public to carry out the state's enforcement function. And it structured those enforcement proceedings to be so burdensome and to threaten such significant liability that they chill the exercise of the constitutional right altogether. The United States has a manifest sovereign interest in suing to redress this violation. SB 8 is a brazen attack on the coordinate branches of the federal government. It's an attack on the authority of this court to say what the law is and to have that judgment respected across the 50 states. And it's an attack on Congress's determination that there should be access to pre-enforcement review in federal court to vindicate federal rights. The United States may sue to protect the supremacy of federal law against this attack. Finally, the injunction is a proper response to Texas's unprecedented law. If Texas can nullify Roe and Casey in this manner, then other states could do the same with other constitutional rights or other decisions of this court that they disfavor. Federal courts are not powerless to craft relief to stop that intolerable threat to our constitutional hierarchy.
All right, Jeff, just real quick in layman's terms, what were the differences the court took up between the whole women's health case and the DOJ case, just to make it a little more clear to those listening along?
Well, in the second case that was heard second this morning, the court was primarily concerned with why is the United States even involved as a party to this case? The Congress has not clearly passed a statute, and there's no court doctrine that really gave the Supreme Court guidance as to why the United States could even file this lawsuit.
Great answer. And then, George, I want to speak to the fact that this was filed as an emergency application. It made the rocket docket in lightning speed before the Supreme Court, even before the lower courts were able to take it up substantially. And I think the near record is reminiscent, I believe, of the 2000 presidential election. Bush v. Gore, and that was in about 3 days. This one in about 10. Speak to the speed of that and the implications it may have for this case and others moving forward.
Well, I think it really depends on how the Supreme Court comes down on this thing. I do think that what they're acknowledging here is that their decision here could have an impact on people making life decisions right now. This isn't a fight over a piece of property or even someone who's been incarcerated who shouldn't have been. This is something that is very time sensitive. And my sense is they want to head this off at the pass. If it's going to be other states that are going to jump on board with this process, now's the time to address it. And I think also the public would probably not appreciate a long delay in trying to address these particular issues, waiting for the substantive part of this. I think this is smart optically for the Supreme Court, but I think substantively it makes sense as well.
Thank you, George and Jeff. I wish I had more time to pick your expert brain on all of these issues, but I really appreciate your time this afternoon to speak with us.